Thank you for joining the My Home Second Unit Renovation Program and working with the Region of Peel. Through this program, not only will you bring your existing second unit up to the Ontario Building Code standard, but you will have a safe, affordable unit that contributes to the affordable housing stock in our community. Today, you will be completing the mandatory orientation session to understand your responsibilities as a landlord. These responsibilities are outlined in relevant legislation and codes that hold you legally accountable to comply with them. The orientation session will consist of 3 parts. We will begin with an overview of the Residential Tenancies Act, an overview of the Province of Ontario's human rights system, and end with an overview of mental health and stigma in the Region of Peel. Each of the 3 parts will focus on how you as a landlord will interact with these topics and the requirements and responsibilities you are beholden to as a landlord. After you complete the mandatory orientation session, you will receive an online quiz from the region to show what you have learned. Failure to complete this orientation session and the follow-up quiz will deem your application ineligible for program funding. Let's get started. The Residential Tenancies Act. What is the Residential Tenancies Act? The Residential Tenancies Act is a law that sets out the rights and responsibilities of landlords and tenants who rent residential properties. As a residential landlord, you must follow this act and govern yourself according to its rules. Who is covered by this act? Landlords and tenants of most rental units are covered by the rules in this act. A rental unit is considered an apartment, a house, or a room in a rooming or boarding house. A second unit is considered a rental unit under this act. Moving on to tenancy agreements. The Residential Tenancies Act guides most tenancy agreements, or leases. Most tenancy agreements entered on or after April 30th, 2018 must use the Residential Tenancy Agreement, or standard form of lease. As a landlord, you are required to use this standard lease. If you do not use the standard lease form, your tenant can demand you do so. You can find the standard form of lease on the Landlord and Tenant Board website. The lease should not contain any terms that are inconsistent with the Residential Tenancies Act, such as prohibiting pets. If any of these terms and others that are not consistent with the Act are in your lease, that term will not be enforced by the Landlord and Tenant Board. A copy of the tenancy agreement must be provided by the landlord to the tenant within 21 days after the tenant signs it. It is the responsibility of the landlord to provide their tenants with information about the rights and responsibilities of landlords, tenants, and the role of the Landlord and Tenant Board, either on or before the start of their tenancy. The Landlord and Tenant Board has a brochure that is entitled Information for New Tenants that should be provided to tenants for this purpose. It was also included in your welcome package from the Region of Peel. The Landlord and Tenant Board. What is the Landlord and Tenant Board? The Landlord and Tenant Board not only supplies information about the rights and responsibilities landlords and tenants have under the Residential Tenancies Act, it also acts as a court and resolves disputes between landlords and tenants. Both landlords and tenants can apply to the Landlord and Tenant Board to resolve a dispute. When should you apply? Applying to the Landlord and Tenant Board to resolve a dispute should be the last effort to try to repair a relationship with a landlord or tenant. If you're experiencing an issue with a tenant, you should first try communicating with your tenant to solve the problem. If you have accepted the $30,000 funding option and are housing a Region of Peel client, you may also contact the housing supply representative you were assigned for primary contact and support. How are disputes resolved at the Landlord and Tenant Board? At the Landlord and Tenant Board, disputes can be resolved through mediation or adjudication. In mediation, a mediator is assigned by the Landlord and Tenant Board to help both the landlord and tenant reach an agreement they are satisfied with. In adjudication, a hearing is held where evidence is presented by both the landlord and tenant. A decision is then made by a landlord and tenant board member based on the evidence presented. An order is then issued. This order is the final, written version of the landlord and tenant board member's decision that must be followed. It should be remembered that applying to the landlord and tenant board to resolve a dispute should be the last effort to repair the relationship. There are other steps you can take before to try to mend the relationship, such as talking to your tenant about their actions and behaviors and how they are affecting you, writing a letter to your tenant to explain your concerns and ask them to change their behavior, and if you have accepted the $30,000 funding option, you may contact the housing supply representative you were assigned for primary contact and support. Moving on to rent. In new tenancies, the landlord and tenant decide how much rent will be for the unit and which services will be included in the rent, such as parking, Wi-Fi, heat, and electricity. It should be noted that a stipulation of the My Home Second Unit renovation program is that you are required to rent the unit at an affordable rate for 10 years, which aligns with the loan forgiveness period. It is required that the rental rate be set at 80% of the average market rent for the municipal area. The Region of Peel will inform you of this rate. In most cases, the rental rate cannot be increased until at least 12 months after your tenant has moved in. The Region of Peel will update you yearly on the new approved affordable rental rate you can charge your tenant. As a landlord, you can collect a rent deposit from a new tenant on or before the start of a new tenancy. The deposit cannot be for more than a month's rent if the tenant pays monthly, and cannot be for more than a week's rent if the tenant pays weekly. When entering into a new rental agreement, landlords and tenants discuss how the rent will be paid. Automatic deposits and post-dated checks are both acceptable methods of payment. However, a landlord cannot require the tenant to pay by either of those methods. Once a payment method is agreed upon, it cannot be changed unless both the landlord and tenant agree. If a tenant asks for a rental receipt for any payment, deposit, or other charge, the landlord must provide one free of charge. The landlord must provide a receipt if the tenant asks within 12 months after the end of the tenancy. About maintenance and repairs. What are the landlord's responsibilities? To keep the rental property in a good state of repair, and to obey all health, safety, housing, and maintenance standards as set out in any provincial laws or municipal bylaws. Both these rules are true even if the tenant was aware of any problems when they agreed to rent the unit. If a landlord is not meeting their maintenance obligations, the tenant can apply to the landlord and tenant board. If the board finds the landlord is not meeting their obligations, there are a variety of remedies the landlord and tenant board can order, such as allowing the tenant to not pay rent until the repairs are completed. What are the tenant's responsibilities? To keep their rental unit clean and up to the standard that most people would consider ordinary or normal cleanliness. Repair or pay for the repair of any damage to the rental property not caused by normal wear and tear. Damage caused by the tenant's guest, or another person who lives in the unit must be repaired or paid for by the tenant. It does not matter if the damage was done on purpose or by not being careful enough, the tenant is responsible. If a tenant has not repaired any damage, the landlord can apply to the landlord and tenant board. If the board finds the tenant should be held responsible for the damage, the landlord and tenant board can order the tenant pay the cost of repairing the damage or even evict the tenant. About entering the rental unit. Entry without written notice. The following are reasons a landlord may enter a tenant's rental unit without written notice. An emergency, such as a fire, or a tenant agrees to let the landlord in. The landlord can enter without written notice between 8 a.m. and 8 p.m. if the rental agreement requires the landlord to clean the unit, or the landlord or tenant has given a notice of termination, or they have an agreement to end the tenancy, and the landlord wants to show the unit to a potential new tenant. Although notice is not required, a landlord must try to tell the tenant before entering the unit. A landlord can enter the rental unit between 8 a.m. and 8 p.m. for the following reasons if they have given the tenant 24 hours written notice: to make repairs or do work in the unit, to carry out an inspection where reasonable in order to determine whether repairs are needed, to allow a potential mortgagee, insurer, or potential purchaser to view the unit, for any reasonable purpose allowed by the rental agreement. As a landlord, you are required to include the reason why you want to enter the rental unit and must state what time, between 8 a.m. and 8 p.m., you will enter the unit. If the correct notice is provided, as a landlord, you can enter the unit when the tenant is not home. Remember, you must give or post this notice on your tenant's door at least 24 hours before the time you wish to enter the unit. About ending a tenancy. What do you do when a lease ends? When a lease ends, there are two options. A new lease agreement can be entered, or the tenant may leave. Renewing a lease. When a lease ends, the tenant does not have to move out. A new lease can be made, or the landlord and tenant can agree to renew the existing lease for another fixed-term period. However, if a new agreement is not reached, the tenant still has the right to stay, either as a monthly or weekly tenant, if they paid their rent by the month or by the week. When this happens, all the rules of the former lease will still apply to the landlord and tenant, and the landlord may increase the rent each year by the guidelines. If a tenant wants to leave. If a tenant plans to move out, they must provide their landlord with a written notice. The proper form for this notice is Form N9 and is available from the Landlord and Tenant Board. However, an oral agreement can be made to end the tenancy early, but it is best to have a written agreement. The amount of notice that is required is based on the rental period. If the tenant pays on a weekly or monthly basis, the tenant must provide at least 28 days notice to their landlord. If the tenant pays on a monthly basis or has a lease for a fixed term, the tenant must provide 60 days notice. Ending a tenancy by the landlord. A landlord may end a tenancy only for the reasons outlined in the Residential Tenancies Act, such as not paying the rent in full, persistently paying the rent late, causing damage to the rental property, illegal activity, affecting the safety of others, disturbing the enjoyment of other tenants or the landlord. The landlord may also evict the tenant for reasons that are not related to tenant behavior, such as the landlord wants the unit for their own use or the use of an immediate family member. The landlord has agreed to sell the property and the purchaser wants all or part of the property for their own use. The landlord plans major repairs or renovations that require a building permit and vacant possession. To end the tenancy, a landlord must first provide notice to the tenant in writing that they would like the tenant to move out. There are forms available from the Landlord and Tenant Board that the landlord must use for giving notice to end the tenancy. If the tenant does not move out after receiving the written notice, the landlord can file an application and ask the Landlord and Tenant Board to end the tenancy. A hearing will then be held to determine if the tenancy should be terminated. The landlord and tenant may both attend the hearing to explain their positions. Remember, the My Home Second Unit Renovation Program requires you to rent your unit at an affordable rate for 10 years. If you are considering ending a tenancy, please contact the program coordinator for primary contact and support. Now that we've covered the Residential Tenancies Act, it's time to move on to the Province of Ontario's human rights system. Ontario Human Rights Code. The Ontario Human Rights Code is a law in Ontario that gives all people equal rights and opportunities without discrimination in 5 social areas based on 17 protected grounds. One of the 5 protected social areas is housing. The 17 protected grounds include race, ancestry, place of origin, color, ethnic origin, citizenship, creed, age, disability, sexual orientation, sex or pregnancy, gender identity, gender expression, family status, marital status, receiving public assistance, and record of offenses. Under these grounds, all people in Ontario have equal rights and opportunities and are not allowed to be discriminated against for any of the above noted grounds in the 5 protected social areas. There are 3 main bodies that implement and interact with human rights in the province: the Ontario Human Rights Commission, the Human Rights Tribunal of Ontario, and the Human Rights Legal Support Centre. Each serves a different function in the human rights system, but all seek to protect human rights in Ontario. Ontario Human Rights Commission. The Ontario Human Rights Commission is an arm's-length agency of the government and was established to administer the Ontario Human Rights Code. Its mandate under the Code is to prevent discrimination through public education and public policy and look into situations where discriminatory behavior exists. The Ontario Human Rights Commission also initiates or intervenes in legal cases, monitors cases, handles public inquiries, and takes part in community outreach and public education on human rights. Human Rights Tribunal of Ontario. The Human Rights Tribunal of Ontario is an administrative tribunal that hears and determines applications brought under the Human Rights Code. The tribunal hears complaints, considers evidence, and makes decisions. Human Rights Legal Support Centre. The Human Rights Legal Support Centre offers human rights legal services to individuals throughout Ontario who have experienced discrimination contrary to the Ontario Human Rights Code. The Centre provides human rights legal advice, assists with filing an application, and provides representation at the Human Rights Tribunal of Ontario. Human rights and housing. Human rights issues can arise in many areas of housing, such as between tenants and between owners, operators, superintendents, and management. Human rights issues can also arise in housing policies, screening practices, and decision-making processes, repairs, common areas, internal and external service providers, as well as in evictions. Discrimination and harassment. The Ontario Human Rights Code and the 3 main bodies involved in implementing it all use and interpret the terms discrimination and harassment on a daily basis, as they are integral to human rights in Ontario. But what exactly is discrimination? Discrimination is when a person experiences negative treatment or is impacted based on one of the 17 grounds in the Code. Negative treatment could involve being excluded, having benefits withheld, or having burdens imposed. Discrimination can be direct and obvious, as well as subtle. For example, if racialized applicants are consistently told that apartments have already been rented, that is considered discrimination. Discrimination can also involve more than one ground that combines to create unique experiences of discrimination. For example, young Black men with mental health challenges face unique barriers when trying to access housing. To be considered discrimination, there is no requirement to determine intent. The effect is enough. For example, discrimination can involve organizational rules or policies that appear to be neutral but end up negatively impacting people based on one or more of the grounds in the Code, such as a building manager requiring prospective tenants to provide an employment history before entering into a rental agreement. So what is harassment? Harassment is ongoing behavior, such as a comment or conduct that a person knows or ought to know is unwelcome and is based on one or more of the protected grounds in the code. Harassment can include threats, questions, jokes, bullying, touching, and name-calling, among others. For example, if a housing provider makes several comments to a queer woman with a small child about the child's lack of proper role models and a real family, that is considered harassment. There are also different forms of harassment. Sexual harassment is when a person makes unwelcome sexual contact and remarks, or takes part in leering and inappropriate staring, propositions someone for unwelcome demands for dates, requests sexual favors, or displays sexually offensive pictures or graffiti. Impacts of harassment. Ongoing or widespread harassment can lead to what is called a poisoned environment. A poisoned environment is a hostile or oppressive atmosphere for one or more people, or one serious incident that is very impactful. Reprisal. Can you be penalized or penalize someone else who has exercised their rights? No. The Ontario Human Rights Code protects citizens against reprisals, meaning you cannot be treated negatively and you cannot treat someone else negatively as a result of exercising one's rights. Duty to accommodate. The Ontario Human Rights Code also requires you as a landlord to remove barriers upon request and accommodate any remaining needs. For example, if a tenant is experiencing a mental health crisis, you have a duty to offer that person assistance. If you do not know how to offer assistance, contact the Region of Peel or a community agency in Peel who specializes in mental health supports. You will learn more about this later in the orientation session. Other examples of accommodation include, but are not limited to, alternate formats of written notices, changes to building entrances, sidewalks, parking facilities, and common areas, physical modifications such as elevators, ramps, different door handles, lower counters, etc., changing a rule or policy, and providing better maintenance such as frequent snow removal. There are 3 principles of accommodation that must guide your efforts to accommodate anyone: respect for dignity, individualization, and finally, integration and full participation. As an accommodation provider, your duties are as follows: to accept accommodation requests in good faith, to request only information required to provide accommodation, to obtain expert advice where necessary, to maintain confidentiality of persons seeking accommodation, to take an active role in ensuring possible solutions are examined, and to deal with accommodation requests in a timely manner. As an accommodation provider, you are required to accommodate short of undue hardship. The factors considered when determining undue hardship include costs. Costs must be quantifiable and related to the accommodation. There are also ways to minimize costs. Look at things like creative design solutions, outside sources of funding, and health and safety. Factors that are not considered include inconvenience, resentment or hostility from others, and other tenants' preferences. Those who seek accommodation also have responsibilities. Their duties are as follows: to inform the accommodation provider of their needs where possible, to cooperate in obtaining necessary information, and to participate in discussions about solutions. Incorporated with the duty to accommodate is the responsibility to also accommodate code rights of others. It must be remembered that the rights of one person may conflict with the rights of others. There are resources you can consult, such as the Ontario Human Rights Council's Policy on Competing Rights. This document provides a step-by-step framework. Now that we have covered the Residential Tenancies Act and the Province of Ontario's human rights system, We will now conclude this orientation session with some important information on mental health and stigma. This section is not intended to make you as a landlord an expert in mental health issues. Rather, it is intended to provide education and understanding into mental health issues many people experience every day. Let's begin. Stigma. We should first understand what stigma is. Stigma is the combination of prejudice and discrimination. It is negative attitudes and negative responses that can make someone feel unwanted and shamed or stigmatized. What is prejudice? Prejudice is when someone has a negative attitude towards a person or group based on their presumed characteristics. This can include someone's gender, sexual orientation, culture, race, religion, age, or their mental health status. What is discrimination? This was covered previously, but remember, discrimination is an act of prejudice, such as denying someone housing because of someone's citizenship, disability, economic status, and many others. Remember that discrimination can be intentional or unintentional and is prohibited under the Ontario Human Rights Code. The combination of prejudice and discrimination creates stigma, which can have several negative side effects on an individual. It can seriously affect the well-being of those who experience it. It can affect people while they are ill, while they are in treatment, while they are healing, and even when a substance abuse or mental health problem is a distant memory. It can prevent many people from seeking the treatment they need, and it can profoundly change how stigmatized people feel about themselves and change the way others see them. In order to respond to mental health issues, we must first understand what we mean by mental health. Mental health is a term that encompasses our emotional, psychological, and social well-being. It can affect how a person thinks, feels, and acts, and can even determine how they handle stress, relate to others, and make choices. It is important at every stage of someone's life, from childhood through adulthood. Over the course of someone's life, many people can and do experience mental health problems. Many factors contribute to this, and people from all walks of life experience mental health problems. In fact, 1 in 5 Canadians will experience a mental health issue during their lifetime. The extent of a mental health issue can vary greatly. For some, this could be seeking therapy for anxiety issues, and for others, it could be much more drastic, such as hospitalization for depression. But what they both have in common is they can affect anyone from any walk of life. People with mental health issues can often feel stigmatized by a variety of factors, such as how the media portrays people who struggle with mental health problems, and a lack of understanding about the nature and outcome of treating mental health issues. This can compound someone's mental health issues by socially isolating that person or leading that person to avoid seeking help. Access to adequate and appropriate housing can play a large role in someone's mental health. As a landlord working with the Region of Peel, you will not only be contributing to our affordable housing stock, but may be assisting someone who struggles with their mental health. Understanding and compassion is key to addressing anyone in the Region of Peel, but is especially important for those with mental health issues. If you, your tenant, or someone you know is experiencing mental health issues, please consider contacting the Canadian Mental Health Association in Peel. This organization connects individuals to mental health information, education, and support services. Thank you for taking part in the Region of Peel's orientation session. We hope that it was informative and you now feel ready to take on your duties as a landlord. If you have any questions about the materials and information presented today, please do not hesitate to contact us, and consult the informational materials provided to you. We now ask that you take the following short quiz to test the knowledge you learned today. It is 10 questions that focuses on what you learned. From the region of Peel, we thank you for taking part in the My Home Second Unit Renovation Program and completing this orientation to become an informed and responsible landlord. If you have any questions, please contact the program coordinator for primary contact and support.